I will now call case number 123559, State of Kansas versus Frank Raymond Crudo. I'd remind council to again, please state your appearances. So we have that on the recording. Thank you.
May it please the court, Peter Meharry for Frank Crudo. And in this case, Mr. Crudo was convicted of possession of marijuana with intent to distribute, misdemeanor possession of marijuana, and then also failure to have a drug stamp for his marijuana. This case arose out of a traffic stop on I-70 in 2014. We've gone through 2 trials and now we're on our 2nd appeal in this case. Kind of the main issues and the ones that I'll touch on, unless the court wants to go elsewhere, are the search of the camper and whether or not that was proper. Then also whether or not the testimony of Officer, I believe it's Rickard, was expert testimony, which would have required pre-trial disclosures. As I said, this arose out of a stop on I-70. Officers with Geary County saw my client driving a pickup, towing a 5th-wheel camper, heading eastbound, and did not feel that his license plate was properly illuminated. So they initiated a traffic stop. And the uncontroverted facts are, as the officers walked up to the pickup, when my client rolled down the windows, they smelled marijuana. From there, the officers searched the pickup and they found a small amount of marijuana, kind of as I understood it, on the center console in the pickup. They didn't stop with the pickup. They then searched the camper as well and found more marijuana, which led to the distribution charge. It's our position that the search of the camper was improper under the 4th Amendment and certainly under the 15th, Section 15 of the Kansas Bill of Rights. There was no indication of any criminal activity in the camper. The officers were clear that they had walked by the camper before they got to the pickup and did not smell anything. They only smelled the odor of marijuana when they got to the pickup and my client rolled down the window.
Would your position be any different if your client rolled down the window and they smelled marijuana and they searched the pickup truck and found 19 pounds of marijuana? Could they then, would there be probable cause to search camper then?
I don't believe so, because they testified they didn't smell anything when they went by the camper. There is no indication, and I don't think you can just automatically make the leap, well, there is drugs here, so there are drugs there. One of the things about the 4th Amendment is you're supposed to have a nexus between the suspicion of criminal activity and the place to be searched. Here, the officers testified they had no suspicion of criminal activity in the camper. They found a small amount of marijuana in the pickup, but I don't think that translates to say, okay, just keep searching and see what you can find. I think the search became overbroad and just a general search of my client's camper without any suspicion of criminal activity.
So it doesn't make any difference that the camper was hooked up to the pickup truck. And so they moved in one, I mean, they weren't separate vehicles. The camper was not stationary. That doesn't make a difference.
We don't believe it does, Your Honor. We believe that there has to be probable cause with regard to the place to be searched. And here there had to be probable cause with regard to the camper if they wanted to search the camper. And that was absent in this case.
If the pickup truck had a bed on it, okay, let's say it wasn't a pickup truck. Let's say it was a car with a trunk and they found 19 pounds of marijuana in the back seat of the car. Could they search the trunk?
I think case law in this from this court as well as other courts say that yes, in that instance, you can.
What's
If-
the difference?
I think the difference is the camper is a separate entity from the car. When you have a car and you have probable cause that there's criminal activity going on, courts, not only this court, but courts all over the place, say you can search anywhere in the car,
Why is that? Because there's exigent circumstances,
correct?
because the car can be moved.
There is exigent circumstances provided because the car can be moved,
But
but
the
there is
camper can
also,
be moved too.
there are also probable cause. And that's the missing link here. There's probable cause that there's criminal activity in that car.
Why wouldn't there be probable cause to believe that there's criminal activity in the camper?
Because the officers testified, they didn't believe anything was going on with the camper. They testified, as I said, they walked by, they didn't smell anything. They testified, we didn't have any indication that there's criminal
And
activity.
why did they want to? That's the uncontroverted testimony. They said, we wanted to search the camper, but we didn't believe anything illegal was going on in there.
Their testimony was that they did not believe there's any criminal activity going on in the camper.
Wasn't that before they found the marijuana in the truck?
That was the testimony, Your Honor, that they said they smelled marijuana from the pickup. At that
So
point,
probable cause can develop as a search is ongoing.
it can, but in this case, all they found was a small amount of marijuana.
I'm just suggesting that that testimony doesn't actually answer, I think, Justice Standards' question, which is why wouldn't, after the finding of the marijuana, why wouldn't there be probable cause to search the rest, all compartments in the vehicle, considered broadly to include the camper?
There's going to be under case law, probable cause to search all compartments of the vehicle. But I think you have to look at the camper and
What
whatever's
if,
towing
what
it
if it's not,
separately.
what if it's not a fifth wheel, but it's an RV that has 5 bedrooms 40 feet behind me?
Sure. In that case, and that's the Carney case, is that the US Supreme Court says you can search the entire vehicle.
And so what, yeah, again, it's the same question. Conceptually, it's difficult to understand why the probable cause analysis would be different between the 40-foot long RV versus the fifth wheel camper.
Because the 40-foot long RV is one unit.
So you're relying
We have-
on the physical connection that a person could traverse without sort of getting out of the truck and going into the camper door.
I think a camper is a separate unit and it has to be viewed separately than the car or pickup or whatever is towing it.
What if it had been a flatbed trailer with a tarp over the 19 pounds of marijuana?
I think, they probably would have maybe seen it, but again, when you
No, there's
have,
a tarp over it, so he can't, it's not plain view.
if it's
it's
not
just a
plain
trailer.
view, I think they have to have probable cause for whatever vehicle or entity they want to search.
So it doesn't matter that it's an RV or that it's someplace you could possibly live. If
No, I think if they had been towing a boat, I think the same rule would apply. You have to have probable cause that that boat is hiding some drugs or there's criminal
So,
activity with.
so
regard
you
to
have
the
a
boat.
black line at the trailer hitch.
That's the line I want to draw.
Gotcha.
Well, I don't actually think you are drawing a line. No one disagrees that you have to have probable cause to do the search. The question is, isn't it an arbitrary distinction to say, oh, you do have probable cause to search the trailer, the flatbed, or you do have probable cause to search the RV, but for some reason you don't have probable cause to search the RV, search the fifth wheel or the boat?
I would say you can't search the flatbed either, Your Honor. I believe that when you have two units, a car, pickup, whatever, and it is towing something, a separate trailer.
Can you
boat,
articulate why that probable cause analysis is different? What is it about the separate unit that changes the level of suspicion about criminal activity?
I don't think it necessarily changes the level of suspicion.
Well, that's what
What-
probable cause is. That's what we're talking about, right?
But what I'm saying is you have to have probable cause for the area you want to search. And when you have two things, when you have a pickup, when you have a camper, probable cause for one does not give probable cause for the other because they are two independent, separate things. You need to have specific probable cause for that trailer if you want to search that trailer. Whether or not it's a trailer, boat, camper, or what have you. And we believe that the Fourth Amendment provides that protection. And here we think it's particularly terrible because this is a camper and it is the personal private space of my client. And that officers in this case, I'll move on in 2 seconds, but I want to leave the court with this on this issue. And that is that the officers searched the private space of my client without a warrant and without suspicion of criminal activity. And we believe that the Fourth Amendment steps in and provides protections for my client in those situations. I'd like to touch base a couple things with regard to Officer Rickard as an expert. And in this case, he testified about the drug trade. He testified about packaging that would be indicative of intent to distribute. And he talked about wholesale pricing. We believe that that is far beyond just something a layperson would know.
Can you suggest where we would draw that line between what is kind of the specific knowledge that's particular to a professional witness or a law enforcement type witness that has experience and training versus common knowledge, and where it's a pretty blurry line. I think you would agree with that, but do you have some advice for us as where we would draw it? I understand your argument. I mean, in this case, the particularized scent, the smell was raw marijuana. They didn't find any raw marijuana in the truck.
Right.
And in fact, it was emanating as soon as he rolled down the window, it was raw marijuana as opposed to any other kind of marijuana, which has a specific smell, I guess, but wrong there. But what about just the particularized knowledge that you specified, how it's packaged, where it comes from? Some of that can be common knowledge, but some of it isn't. Where would you draw the line?
I'll freely admit it's probably going to be a blurry line, and it probably one of those that is going to be somewhat case by case basis. But I think kind of the baseline you start with is, what would a lay juror know? Would a lay juror know what the price of marijuana in California is versus what the price is in North Carolina?
Well, how do you separate that? Wouldn't a lay juror know that 19 pounds of marijuana specifically packaged and even identified by a particular type of marijuana could imply or is for distribution as opposed to personal use? Wouldn't that be a kind of a common, would that take an expert to testify to that?
I think it would. As far as the specific packaging, I don't think most people, some people may know, but most people don't know how marijuana is packaged. They don't know how it's packaged for personal use. They don't know how it's packaged for distribution. I think that goes beyond what you could expect a lay juror to know.
Do most
Does it?
people know how much 19 pounds is?
I don't know. And I would argue certainly marijuana.
You would need an expert to talk about 19 pounds, what 19 pounds is?
I think marijuana is a different cat than some of the other drugs, as far as quantities, Your Honor. Amounts of marijuana is, you have to have more for the same kick as other drugs, so to speak. So just because it's 19 pounds, I don't think that automatically would tip a jury to say that's clearly distribution.
And who should make that judgment of what that jury that's sitting in that courtroom? I guess this is a good point to ask as a reminder what our standard of review is.
We believe that this is on experts, I think it's a mixed question. Whether or not a person is an expert under the statute, I think is a question of law for this court. Whether or not they're qualified, I think probably delves into abuse of discretion. But it's a district court's judgment and determination at the outset. This is expert testimony.
So you think we're in a better position than the trial court to decide what the jurors would understand given the evidence? Where that line would be between what they can understand without the assistance of an expert and when they need an expert?
I think this court would be in about the same position because you're looking at just the common knowledge layperson standard. I don't think that necessarily is jury specific such that Cloud County is one standard, whereas Shawnee County is another. I think you're having that kind of baseline standard of what's common knowledge, what a lay juror would understand. And from there, this court can say, I don't think they would understand this. I don't think they would know how drugs are moved, how they're packaged, what the pricing is. That is beyond a layperson in our view.
I want to go back to that standard of review real quick. So for the district court determining whether or not this is under the statute, when you read the statute, whether it's going to be expert testimony or lay testimony, is that decision, how is that decision reviewed by us? Is that abuse of discretion?
I think whether or not the person is an expert is a question of law. Whether or not they fall under the statute requires interpretation of that statute. And again, is a question of law for this.
Well, no, I'm more talking about, I mean, there are certain rules if someone, not whether or not they're an expert in that area, but in other words, is the testimony under, is the expert testimony going to, specialized knowledge, scientific, technical, or specialized knowledge? That decision saying, the judge saying, that's not scientific, technical, or specialized, so I'm going to let you testify as a lay person. What is our standard of view for that decision by the district court?
I think that's a question of law because you're determining whether or not that witness falls under that statute. And I think that involves interpretation of that statute, which are questions of law for this court. Whether or not at the start, if he is an expert, I think is a question of law for you to determine whether or not 6456 he falls within that statute.
So if it is an error of law, is it subject to a harmlessness test?
Yeah, we have argued that it is subject to harmless error analysis. And here you can't say it's harmless because of the importance of this testimony towards the charge of distribution. That was the major charge in this case. The first trial hung on the issue of distribution. State retried my client on the issue of distribution. That was key in this case. And his testimony, his expert testimony, was key for the state to make their case.
Does it make any difference that he was testifying as a fact witness
Yeah.
versus someone who's brought in after the fact to review documents and give an expert opinion?
I will disagree a little bit that he was testifying as a fact witness solely. He certainly was testifying to the stop and what he saw, what he observed. But then when he's talking about the marijuana trade, he's not testifying to his perceptions about the marijuana trade based on the stop that night. He is testifying based on his training and experience that have nothing to do with this case. That's prior training that he's gone through with various law enforcement academies. So in that regard, he is giving an opinion on the drug trade, and that is not just a fact witness.
So it's the fact that the testimony exceeded the scope of the facts of the case that he was, from your perspective, he's talking more broadly about things that are outside the scope of what happened in this case.
I think that's correct. He's testifying beyond his perceptions of the stop.
How did the, I should know this so I apologize, but how did the evidence from the first trial differ from the second trial? So this 19 pounds of marijuana, did the officer give the same testimony about distribution and pricing and the things that you think require an expert testimony?
I think it was pretty similar, Your Honor. I don't think it was, I think probably not identical or anything, but I think it was along the same lines. I'd have to go back and check.
And it goes to the harmless error calculus, if you will, that, if the state tried to bolster its case on distribution because that's where they hung, and this was the way they did it, then the admission of this testimony might look a little more harmful than it was the same testimony and this group just believed the evidence as a whole as opposed to the first trial.
I think it was along the same lines as far as what he testified between the trials, but I still think it is problematic because it was the only issue in the second trial. And this was the key evidence against my client as to the distribution charge. If there are no other questions, we would ask this court to reverse this matter for the reasons that we've cited in our briefs. Thank you.
Thank you, Mr. Herring. Mr. Cruz?
May it please the court, Tony Cruz on behalf of the state of Kansas. As this court has already pointed out, it's very difficult to kind of ascertain where this court is supposed to draw that magical line of when officers have probable cause to search a vehicle and the containers. Because
Mr.
that-
Cruz, could you maybe adjust your microphone and see if we can pick you up a little better?
Sorry, they're doing a
Thank
lot of, they're
That's-
doing a lot of control burns and I'm breathing a lot of that smoke in, so I'm a bit raspy.
I think we all understand, but I think I can hear you better, so thank you.
Okay, I apologize. No, and what this boils down to is whether or not, or if this court's willing to basically forego the Carroll doctrine. Because as we all know, the Carroll doctrine says once you have probable cause to search a vehicle, you can search all of the containers which may contain that contraband. In this particular case,
Isn't, or at least I'll articulate my understanding of that rule. The reason for that rule isn't because we just want to sort of make and draw arbitrary lines. The reason for the rule is that the belief, the view that once you have probable cause to search part of a vehicle, you actually have probable cause to search the entire thing because it makes the level of suspicion has crossed that threshold to where law enforcement has that reasonable belief that there could be criminal activity in any part of what's sitting on the wheels.
right,
Would you agree with that?
yes, yes.
But if it was a cell phone inside the vehicle, obviously they wouldn't have been able to search that without a warrant under the same doctrine. Would you agree with that?
Correct, because we have a separate set of laws for cell phones.
And I guess it is, what is it that distinguishes an item like that, from the Carroll doctrine itself, where you could search containers? The fact that it can't store other incriminating evidence itself, or is it because there's a higher expectation of privacy on some items that might be found within a larger container?
For cell phones, we have a very specific case law dealing with the U.S. Supreme Court that have said that cell phones and now that we're talking about smartphones contain a lot more that information, personal information, than just simply what they used to be able to do. It used to be you had a cell phone, you could make phone calls. Now they've got pictures on them that they can access the internet, the emails, texts. And so there's a lot more personal that information that's involved with,
Because there's a
having cell
higher
phones.
expectation of privacy.
yes. And then that's why if in this case they had found a cell phone, they would have been required to have obtained a search warrant to get into that cell phone.
And if the fifth wheel or pop-up was the person's primary residence, would there be an argument, at least the same rationale, that there was a higher expectation of privacy?
I believe the case law says that it depends on how that fifth wheel happened to be found. If in this particular case that it was mobile because it was still attached to the truck and moving on I-70, there is not that expectation of privacy because it would be the same as having an RV. If that fifth wheel had been in an RV park where it been detached and you had water lines hooked up to it and power lines to it, I believe then that would be different because at that point, it's not inherently mobile. The thing's actually attached and it's being used as a residence.
Don't these things go to exigent circumstances, not to probable cause?
To search it without a warrant, yes.
Right. In other words, the distinguishing things that you're describing, the factual circumstances, don't actually go to the probable cause analysis. They go to other parts of the analysis.
Yes, sir.
Yeah, I guess I just don't understand the idea that differing levels of expected privacy would change the probable cause analysis. Do you think that it does?
And it would to a certain extent, and the specific example was that the cell phones. And there is a plethora of case law, not only for this court, but also the US Supreme Court, saying that even if you were to find a cell phone during a traffic stop, you can't search it. Even if you find contraband in that vehicle, you can't search that phone unless you have a search warrant. So that's an expectation of privacy. You still have
Can you
still
seize it?
probable cause. You can seize it. You just can't search it.
What if they would have found a gun? I don't know, with the serial numbers filed off. Could they search where the car lighter is? You know, the whole line of cases that when at least when you have a warrant and your particular warrant is when you're looking for something and you can't look in a place where obviously what you're looking for wouldn't fit.
Okay, so in your honor's the example, are you saying that they smelled the odor of marijuana and that caused them to search the vehicle and they found a gun?
I guess it's not a very good example.
Yeah, see, I'm just trying to make sure I have the facts straight, so.
Well, no, but they didn't smell the odor of marijuana. I'm not sure, the gun was in plain view.
Okay.
And so they were looking for other guns. Can they look in crevices that wouldn't hold a gun or containers?
I don't think they'd be able to look in areas where what I would call firearm paraphernalia couldn't be found. For example, when you're talking about a firearm, you're not just talking about a gun, you're also talking about bullets, and you're talking about potentially magazines or a gun case, a gun kit, a gun cleaning kit. So if you find a firearm that you believe is contraband, I think you're allowed to search in areas that in the vehicle that you could find contraband associated with that firearm, to include bullets. But again, depending on the circumstances, it may be a better idea to just obtain a search warrant, just so you're covered.
If you assume we accept your argument that the pickup and the trailer, the fifth wheel, is all one unit and probable cause for one is probable cause for all, give me your best argument why that the conviction for simple possession is not a lesser included of possession with intent to distribute.
Okay, so during the first jury trial, we presented evidence only as to the bud of marijuana that was found inside the truck, and also the 19 bags of marijuana that was found beneath the shower that was inside the trailer. And that was, we were going to stick with that evidence because the other marijuana that was located beneath the stairs that also had a thing, a grinder, some rolling papers, that was not tested by the KBI. So we were not going to allege personal possession of that to allege marijuana because again, we had no scientific testing for that. It was defense counsel, apologize. That it was defense counsel that introduced the bag of marijuana that was beneath the stairs. And that's what the jury found him guilty of that marijuana. In the second case, and they also found him guilty of no drug tax stamp. The only evidence pertaining to a no drug tax stamp pertained to the 19 bags of marijuana. The jury hung on the possession of marijuana with the intent to sell charge. And that's what the second trial was on. On that one, the only evidence was the 19 bags of marijuana that the defense still alleged that was, was still possessed for personal use. So I think that the fact that you had personal marijuana alleged to have been found in one part of the vehicle, and then you had a separate 19 bags of marijuana that the officer said that was for distribution. I think that's the difference.
So could you have charged 19 separate counts of possession with intent to distribute? Because
No, no,
19 bags?
no.
Because you're a benevolent prosecutor or because as a matter of law, you cannot?
As a matter of law, because this would be for example, we do have case law that says, like, for example, if we were to do that a search warrant on a person's house and we found methamphetamine just for personal use, but he found it in the living room, in the bathroom, in the bedroom, in the kitchen, that in their car, that on their person. The state, as a prosecutor, I would only charge that as one count because the allegation is, in my perspective, that they're alleged to have possessed all of the meth. However, it's still, it doesn't change the dynamics of its, the intent to sell or if it's for personal use. So it'd be on one count. And then you get into the whole multiple acts, that analysis. And again, I think if you find that type of drugs throughout a large area, that this court would not uphold the 19 count because again, it's just one incident.
Can I-
Before, oh, no, go ahead.
Well, I was going to move him over to.
That's what I was
Okay.
going to do. So you can go ahead and
So
I'll follow up maybe.
Move you over to the expert witness question and just ask at the outset, do you as a prosecutor or in your knowledge of how cases are typically prosecuted, does the state certify other expert witnesses? And I'm thinking of coroners who testify about cause of death, the KBI lab techs who testify about drug identification, or perhaps who do the DNA analysis.
Yes,
Does the state certify those people as experts?
yes.
So why wouldn't you go through that process when you have a law enforcement officer who's testifying outside the scope of the actual facts of the case about things like the drug trade in California? In other words, I mean, you do it with other experts who are necessary to your case. Why not do it for the law enforcement officer?
Because those other witnesses, when you're talking about doctors and you're talking about forensic chemists, they have a very specialized skill set that's all that they do. So they have extensive education, they have extensive training, and that's all that they do. And so because, for example, if you're going to call a doctor that in a homicide case, more likely that you would have them testify as to the cause of death. Well, they're the ones who have, that training and that experience to be able to ascertain that the victim died that either at a certain time or a certain manner.
How is that different from a law enforcement officer who has specific training and experience in a small area of human knowledge?
Because what they're testifying to, in my opinion, that's not so scientific or complex or technical that they would qualify as an expert.
What if,
They
what
have-
if this law enforcement officer had a stellar career as a physician before becoming a police officer? Would they be able to testify about cause of death? I mean, I would assume the answer is no, without being certified as an expert. So you're trying to draw a distinction between the knowledge base.
And again, generally speaking, when you call those types of experts to testify, they're talking about things that are so foreign that you really need somebody to basically walk a jury through every aspect of their testimony. Where when we're talking about drugs and the drug trade, you're not going to that level of explanation.
So this is common knowledge to the 10th power.
This is common knowledge for officers, I think in general.
Well, that is what lurks behind all my questions, which is it strikes me that the state wants a general rule that law enforcement officers are exempt from the expert witness statutes. But in the course of our short conversation here, it strikes me that you've just said that they're not, essentially. So why wouldn't we just apply the typical, is this outside the ordinary understanding, common knowledge of a juror? Why wouldn't we just apply that to every subject that an officer is going to testify?
to the flip side of that, that would mean that the state would have to certify an officer if they have any sort of specialized training. So for example, if they're running a radar gun, because that's specialized training, then I would have to certify them as an expert, even though most officers will tell you, I was trained to turn it on and I do the calibration. How the physics of how the radar gun works, I have no idea, don't want to know, because that's just not what I do. And so for me, having to certify an officer for every aspect of their possible testimony on things that they see every single day.
It's not every aspect of their possible testimonies when you're trying to utilize their expertise in a specific area to gain a conviction on a specific element of a crime. Here, it's the intent to distribute, and you're trying to, in a way, bootstrap some of the common experiences, but really the specific knowledge they have about the drug trade that isn't common, ordinary knowledge. And along with Justice Stiegel's questions, what's the problem with saying, in this particular case, this officer is going to testify about the drug trade, his knowledge and his training and his experience or her experience with the drug trade, and disclose that pre-trial. I don't see these are serious cases, results in serious deprivation of liberty. It's not just a common possession case. This is a 10 to 15 year sentence this person is facing. And what's wrong with the state clearing that hurdle to deprive that person of his liberty for 15 years?
As far as having them declared an expert, that wasn't done. But this wasn't a case where the defense was blindsided by the officer's testimony. He testified at prelim. He testified, I believe, twice during two different suppression motions. They had copies of his affidavit. And so
I'm not talking about surprise. It's just that what the evidence is that's provided by the officer, I think is in some of this, in what is offered, is beyond the common knowledge of a juror, of these people out in the audience. It just is. And so I guess I'm asking you, what is the problem, as Justice Stiegel asked, with designating or specifying this particular state's witness is going to testify about this?
I think that would boil down to honestly, the facts of each case and honestly, how much experience an officer has, because in the one hand, real easy to certify an officer who has a 15-year career and has a lot of specialized training, as opposed to a new officer who has not as much training, but has the exact same facts. Be real easy to certify one, probably not going to be able to certify the other one. And then we're stuck in the same boat because you've got the defendant in two cases that did the exact same thing, though, because one officer is brand new, doesn't have all of the extensive training, they're not going to be able to be certified as an expert.
Isn't that case in point? That and someone without the training experience, they're going to testify to this anyway, but they don't have the training experience to do that?
As an expert, I don't think that they would be certified by the court to be able to testify about that. And again, we have to go through a docket hearing to determine whether or not that they're an expert or not. If the court deems them not to be an expert, they're not going to be able to testify even.
But you can bring the veteran in to testify.
Assuming
Because,
that
yeah, whether however many pounds, 19 pounds is distribution, whether the drug trade goes from west to east, whether people want to drive faster because they don't want to be in the road as long. I mean, those are things that you could just have another be qualified as an expert to testify.
if you're operating in a bigger jurisdiction, that'd be quite a bit easier. But I'm also thinking about smaller jurisdictions that don't have that resource available.
Why isn't it enough for the officer to just say 19 individual 1-pound bags all wrapped up the way they were found is, you know, a ridiculous amount of personal use. Doesn't that get you all the evidence you need on the intent to distribute?
Not according to State v. Smith, no. Because State v. Smith was a case where
Well, you get an
Yes.
inference. I mean, we've been round and round on that. And the pick instruction tells them they get an inference.
but this court's also held that that pick instruction is not accurate.
Right.
So we
Right.
can't use it anymore.
Let's not start on that,
Right.
please. But I am serious about, and I guess I don't appreciate, what is it you think you need to establish this intent to distribute beyond kind of the obvious facts of what the officer saw?
Oftentimes, in dealing with certain cases, we have to explain the conduct of the officer and also explain why they did certain things, and also why, in this particular case, arrested somebody for possession with intent. And so everything that they've known, based on that their training experience, goes into that. When you present it to a jury, you tell a jury, that's 19 pounds. Juries don't. It's like, okay, was that a lot? Is that a little, small amount? And so we have to explain to them what 19 pounds really means.
Other questions?
Thank you.
Mr. Green.
Just a couple comments that I'd like to make on the issues with regard to the expert. I think it is important to note, I think the state wants to have it both ways. They want to have an officer get up there and testify as an expert, but without having to disclose them. And one of the reasons why we have the disclosure statute is so the defense can question those expert opinions. The disclosure requires information as a written report, witness qualification, and witness opinions. They don't want to give that up. They don't want the defense to be able to go out and get an expert and say, look at this, what they're saying. What do you think? But they want to put that into trial. And here, then they paint him as an expert. The state questioned Officer Rickard about his qualifications, about how many hours he had in drug interdiction training. So they want to be able to bring him out as an expert, but not follow the statute. He was an expert in this case, and it required pre-trial disclosure. And I think it's pretty clear that he was an expert, because if the defense had put anybody on the stand to say the exact same thing, the district court would not have allowed it. They would have said, this is expert testimony, no disclosure, no witness. So we believe that was an error on the part of the district court, and it did matter in this case because distribution was the main charge. It was all that the second trial was about, and this was the best evidence the state had on that issue of distribution. So for those reasons, we would ask this court to reverse this matter for the reasons we stated today and in all the briefing. Thank you.
Thank you, Mr. Meharry, and thank you, Mr. Cruz, for your arguments in this case. The court will now take this appeal under advisement.